I was actually an extremely shy little kid. As I was growing up, I fell in love with researching, writing, arguing, and that really just catapulted me into wanting to be an advocate, wanting to make a difference. And you are what you eat, and you become whoever you're learning from. And so I wanted to make sure I was learning from people who were well respected in the legal community. I don't like the use of it in law. It's something that is a necessary part, and I'm embracing it and want to learn as much as I can about it because I know that we're going to need to use it. I haven't practiced in the world that we were in before COVID, where you'd go to a motion calendar, there'd be 100 attorneys, and you'd see 3 other attorneys that you have on other cases. Now, you don't have a personal connection with anyone unless you go out and get it. When you're a younger attorney, they're gonna just try and make you think and doubt yourself.
This is The Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadeo. My guest today is a partner in the Miami office of Hamilton Miller Birthisel, where she has established herself as a force in complex commercial litigation and insurance defense. From securing multi-million-dollar summary judgments in novel COVID-19 disputes to embedding herself with insurance syndicates in London, she brings a global perspective to her practice. She is also a pillar of the South Florida legal community, currently serving as president of the Miami-Dade Bar Association. It's my pleasure to welcome Melissa Jordon to the podcast. Welcome, Melissa, and thank you for being here.
Thank you so much, Aniket, for having me here, and I'm excited to be able to share and talk with you all, and thank you for having me on today.
It's my pleasure, Melissa. As you know, Melissa, I love to start by asking each of my guests to share either a fun fact about themselves or a cringe joke. Which will it be for you, and what is it?
So mine's going to be a fun fact. I'm not very good at cringe jokes. So my fun fact is actually that I won a grand prize of a radio contest when I was 18. So essentially, whenever you'd hear people saying, there's a grand prize on the radio, call in, be the 9th caller,
Right.
like that. And then you get entered into like the grand prize where they'll the round trip travel or whatever it is. And my favorite band when I was in high school was the Goo Goo Dolls. They were the first band that I saw in concert. And so when you entered the contest, it was just to win tickets. I just wanted to win the tickets because I'd already seen them. So I'm like, I don't really want to pay to go again. So I kept calling in. And on the last day, I had almost given up on it. But I called in. I was the 9th caller. And so you get the 2 tickets, and then they say you're entered into the grand prize, which is a Star Barbecue with Michelle Branch and the Goo Goo Dolls for the concert they're going to do. They're going to perform your own mini concert in your backyard, and they cater a barbecue, and you have up to 40 guests. And so I was like, oh, that's great. It's not going to happen or be real. And turned out I won the grand prize, and we ended up having the concert at my house. It was an 18-year-old's dream come true with a bunch of my friends and family, and it was just a picture perfect day in the middle of the summer. It was absolutely amazing.
That is amazing. That might be one of the most fun facts I've ever heard on the podcast or off. That's awesome. Yeah, best of the early 2000s. I remember. I remember that. I remember music with Iris and all of that. That's awesome. Thank you for sharing that, Melissa. That was amazing. Well, so Melissa, I think of every attorney who makes the time to be on the podcast as a superhero, and every superhero has an origin story, and I would love to learn yours.
My superhero story isn't actually that super, but it's more so when I was growing up, I was actually an extremely shy little kid. As I was growing up, my bigger sister, who always looked out for me, was like, oh, you should go join this club or do, this, club activity after school, whatever it is. And so I fell in love with researching, writing, arguing. I joined Model UN as a kid in high school. I ended up continuing to do it in college very, very competitively. And that really just catapulted me into wanting to be an advocate, wanting to make a difference, and finding, what would be the best avenue for that. So I pretty much always had the mindset that I wanted to go to law school. I'm the first attorney in my family. And so that was a whole different challenge and experience, especially because I grew up in Connecticut and I did not plan or expect to be living down in Miami, or to stay in Miami. My plan was always, I was always going to be in either, Connecticut, Massachusetts, New York, be in Boston, be in Manhattan. That was kind of the goal. But instead, my dad convinced me to apply to a college that had a good football team because he wanted to see college football. So, so that's how we ended up applying to the University of Miami and coming down to Coral Gables. And it's been a adventure since then. When I applied to the university, had a 3+3 program at the time that was called their honors program in law. And so I applied to that program, and the way it worked was you had to meet all these honor requirements that you had to do in 3 years versus 4 years that most students would be doing. And then you would take your LSAT a year early, you'd apply to the law school a year early, and if you were accepted, they'd basically blind your application so they didn't know you weren't graduating. And if you met all their criteria and they accepted you like they would with anybody in the normal pool, you could just matriculate into the law school a year early, and they double count your credits for that last year. And so I told my parents, I did a whole cost benefit analysis chart with all my schools. And I just said, even if I got into my dream school, I'm still going to go to you. This is too good of an opportunity. So I ended up down in Miami, and I went through the program. I got accepted, did the 3 and 3. It was an interesting experience because I was a little bit of their guinea pig because there hadn't been that many people who had gone through it. I was the first female graduate of the program, but it gave me a great opportunity to kind of catapult into law even earlier than most people because I got to skip out on an extra year. And it also was a little bit of a comfort too, as being my first experience with law school, no one in my family having any law experience, to be in an environment I was already very comfortable in because I had already been an undergrad at the university. I still had a lot of my friends there. I had worked in the law school as a law student. I mean, as a work study is what they had when you're an undergrad. So I was familiar with a lot of the judges, the attorneys, and I just fell in love with it even more. So it was very comfortable to start my law school life in a place that was already becoming a home where I was growing up and becoming an adult. And so I absolutely loved my time at the University of Miami, and that's why I'm still a very big part of it, because all of the people that I've met have influenced and impacted how I ended up staying here in Miami, because all of my job opportunities have come from alum. And what's even more amazing about it is just that, the world's a big place. When you go somewhere new, you have to rebuild an entire network. But what's incredible to me is that the university has such a tight network that even the first person I worked for before even starting law school was a Connecticut double cane. So it doesn't get much better than that. That was someone who had a lot of the same hobbies, interests, knew a lot of the places that I was, and really helped me in my year going into law school. And that first summer I worked for him. And then when I started my first job, my first boss coming out of law school and starting as a first-year associate, he grew up 15 minutes away, and his parents still lived in the house 15 minutes away from where my parents' house was in Connecticut, and also a law grad. So it was just a wonderful network that really was a nurturing environment that allowed me to grow and learn as much as I could, and gave me great opportunities where I had very strong role models and mentors that elevated me, especially as a young female in the legal practice, as they were both established gentlemen in their areas.
Wow, what a remarkable story. Thank you for sharing that, Melissa. Yeah, so many firsts. I mean, first attorney in your family, first female graduate of this new program. That's remarkable. Kudos to you on those accomplishments. So this program, it was 3 years of undergrad plus 3 years of law school. So you could finish your college and law school in 6 years total, if I got that correct?
Yes. So you basically got to skip a year of undergrad. and you did your full law school. You don't get to skip any of the classes they want you to take there. But yes, it was a great opportunity there. So I actually ended up graduating from law school when I was 23, I believe.
Wow, that's remarkable. You mentioned double cane. What does that mean?
Yes. So a double cane means that you're a double alumna or alumni of the University of Miami.
I see.
So because the team is called Hurricanes, and so
Sure.
we abbreviate it as Canes for short. And so a lot of the campaign and association and name is once you graduate, you become a Cane for life. And so everyone's just called a Cane.
You mentioned you got your first position out of law school, out of this 3+3 program through a U of M alum. Can you maybe walk us through your trajectory from that first job and your experiences then to where you are today? And then we'll talk about some of the things you do today.
Sure. So I was at my first job out of law school for 5 years. I absolutely loved it there. My boss was an amazing mentor to me. It was at Walton Lantoff Schroeder in Carson, which was one of the oldest law firms in South Florida. It's just actually celebrated its 90th anniversary a few years ago, I believe, because it's great. They still invite me as an alumni of that law firm. And that's where, a lot of the opportunities that I was able to position myself and move into were from having the opportunity and the mentorship that I did receive there, and pretty much letting me be as hands-on and receiving credit for anything that I worked on, anything I was arguing, helped me really, fine tune and hone how to interact with opposing counsels, how to, convey your point, how to not get a hot head in a moment where, everyone's just like, I'd really like to, get at this person that's really annoying you or is doing something that to be unethical or wrong, and figuring out what's the best method and way to handle that professionally and ethically. And that was the most important thing to me when I was even picking a job, is I wanted to pick an environment that I knew was a respected environment, had a history, had a good reputation. That was all extremely important to me, because you are what you eat, and you become whoever you're learning from. And so I wanted to make sure I was learning from people who were well respected in the legal community. And that was the experience that I got, that it allowed me to, take on leadership roles. Within a few years, I was starting to take charge of the newer associates. I even had my own associate. I had been elevated to junior partnership on a very expedited basis, because the opportunities presented themselves that I was able to take advantage of, and that we were crushed with at the time doing mostly first party property insurance defense, and we were crushed with Hurricane Irma litigation. And so when that happened, I kind of really stepped up and helped to bring in a lot of the changes, the procedures, and organizing, because it was an absolutely unprecedented time for all of the carriers all over the country. But even for our clients, we were all handling over 200, 250 cases each, because it was just a floodgate. So that really allowed me that when I took advantage of that opportunity, instead of it being something that was crushing me and a lot of my other colleagues, I was just picking up whatever the slack was. If someone couldn't answer something, I was volunteering to go cover a hearing, go cover a deposition. If they weren't getting through on the phone, I was fixing whatever the issue was, even if it wasn't my case, just so that way I could keep the team moving and rolling. And that ultimately ended up leading into running one of the other practice groups for their cases for one of our other first party clients. And that was a lot of different hats that I started to be able to get to wear and do and execute at a very early stage of my career.
That's amazing. One line that you said really stood out for me. You said you become who you're learning from, and that's a great line. Thank you for sharing that. I'm gonna remember that and maybe use that and cite you in the future. So was this all, Melissa? Was this all at that first firm where you spent 5 years? Okay.
Yes.
And then can you maybe walk us through the transition to your current firm where you're a partner?
Sure. And so in between, I had worked at another firm. I worked at Woodsmith, Henning and Berman. So it was a completely different change, because I loved everything I was doing at Walton Lantoff, but the issue I was having is I was starting to feel that I was regurgitating the same information that I'd already learned, and I wasn't learning something new. And I wanted to keep pushing that and find more. So, and it's a wonderful firm. I love it there. So, but they're a mid-sized firm. So I went to the complete opposite spectrum to a large firm where that firm had about 50 attorneys. This firm now had 400 attorneys and was based out of California. And so it was a completely different experience. It just gave me another perspective and opportunity to learn, grow, execute, and find more areas that I was passionate about in law and in honing my practice even more so. And so that is where I was exclusively doing work with the London market and a few domestic carriers. And I was doing both open market work, I was doing binder policy work, coverage work. And I had started doing some of those things at Walton Landtap, but this was where I was pretty much dedicated my time to and really got to take more deep dives into doing more research and writing and opinions and further honing those skills while getting to continue to grow and build other associates and teams as I was the senior counsel there for the Miami office and helping to grow the work that we were doing there.
That's good. Let's talk about London for a second. So I believe in a couple of years ago, you spent about 3 months in London with an insurance group. And so can you talk about that experience, what it taught you, how that applied to the work that you do or did back then in the US?
Sure. And so with the secondment, that's something that I did that once I ended up at Hamilton Miller Birthisel. And so when I say ended up, it's also just as a completing the circle and the loop of where I'm at. That, again, the same thing is to that same point is you are who you learn from. And so they actually were my first work family. That I was a law clerk when I was a second year summer between my 2 and 3L year of law school. And so I worked for them that whole summer. I was invited back and worked for them during my last semester at the University of Miami while I was finishing my degree. And then at that point, they didn't hire first-year attorneys. And so that was how I ended up going to and applying and becoming part of Walton Landtap. And then eventually the stars aligned and the right situation worked out that I spoke to our managing partner at Hamilton Miller Birthisel, Jerry Hamilton, who's just a absolute powerhouse, all around best guy that you can find. That I don't know how he gets everything done. I think he maybe only sleeps 4 hours a night. He's like a superhuman, but very charismatic guy that really pays attention and helped me kind of figure out what did I want to do and make and build as my practice and focal point. And so that's where the project of trying to start this, we were building out our property team and casualty team at the firm because it was historically a maritime and personal injury defense. And so we started building in the property part. I had the coverage experience and had the background of both the domestic and the London market clients. So then the opportunity was presented to do the secondment with Canopius, and that was presented to me at Hamilton Miller Birthisel as something that would be a valuable benefit for both me to gain that experience and to be able to share that information with our firm and use it in our daily practices. And so when that started coming to fruition, the amazing part about that was you really get the opportunity to speak, learn, and talk with the people who are handling the claims on a day-to-day basis, learning their system and understanding how different it is than any of our domestic carriers. And so where I already had a very good working knowledge of how the market operated in terms of how my clients wanted, me to present things to them, what conversations we needed to have, and what their, normal appetite or desires would be in terms of defending or litigating or trying to resolve a claim. And this just gave an overarching experience that was just invaluable in that I just got to really see, what limited information they have and how important the relationship between the attorney firm and syndicate that's part of that London market that you're working with, how important that transparent relationship is, because there has to be an exchange of information on on a much different level than you're getting when you're just kind of relaying in real time to one of your domestic carriers as you're going through different layers, and information's getting lost along that way, to make sure you have that relationship with your client. That way you can call them and explain to them what's going on, and that they are understanding and really appreciative of the information you're saying, because you're the eyes on the ground, and they're not. They can't do that. And so it's an extremely important relationship. And so learning more of the history of that relationship, of the London market, of the day-to-day operations, was just a phenomenal experience, and to which you really get to know the people too. And that's the best part about it is I'm a people person. I like people, and getting to interact and learn from some people who have been in the industry for decades is there's nothing else like it. So it was a once in a lifetime. That was incredible.
That's awesome. Switching gears to specific matters that you've been a part of. So one of them, I was doing my research, and I found that you had successfully defended an almost $10 million COVID-19 business interruption claim for a Miami Beach hotel. Can you take us into that matter and how you worked on it and what the outcome was?
Sure. And so that was a matter that I actually was working with another law firm. We were both working on it together because this was a very complicated claim. During COVID, it was very uncharted territory where no one quite knew what was happening. And this was right when all these decisions were starting to come out. And so I was, again, the eyes on the ground, because I was here in Miami. The claim and the case was here in the Southern District of Florida. The hotel at issue, it was on Miami Beach, and the claims that were being made, I was working with our co-counsel who was assigned on it from the carrier we were representing, was based in New York. And so we're working together on building the case law out, figuring out what information discovery we needed, what was the way rulings were going in other jurisdictions, to figure out, is this going to be helpful or disfavorable, and comparing our policy language with other cases that had been decided already. It was a lot of research, a lot of communicating, a lot of calls, and figuring out what our strategy was on it, in terms of gathering all the information that we needed, at the same time of figuring out what was the way we could lay out this information, that ultimately we were able to prevail on the summary judgment without hearing even. We were granted the summary judgment just based on all of the research, citations, and information that we put into our motion. It was really spending the time and having those conversations and being able to work with my partner attorneys who were in New York, and I was the admitted attorney that was handling most of the litigation portion of it, and us working together on drafting all of our motions and pleadings in the case.
That's great. You mentioned you were a people person, right? And so to what extent do you think that for complex matters like this, complex interstate matters like this, where you have one attorney in New York and you're based in Miami, to what extent do you think, in addition to the legal and technical skills and knowledge, and of course the eyes on the ground that you have, to what extent is communication, relationship building with that attorney, with other stakeholders, to what extent do you think that's important in delivering the kind of returns that you did for your client?
Well, and I think that's ultimately one of the best aspects of the job, that if you can figure out how to work well with somebody else, you're going to provide the most efficient and best representation you can for your client. That's honestly the thing you want to be doing. And so it's helpful when you have other counsels that you're working on, because a lot of the times you can even rely on them and you can lean on them when you need to. And it helps you balance out, because instead you're really like a double power instead of two other forces. If you're operating your own circles, it's not working. But if you're, going like this and you're, symbiotic in that relationship, it can help you be more powerful in your position and ultimately provide better results for your clients. And so to me, it's one of the most important parts of the job, that regardless of whether or not you're transactional, you're a litigator, you're a clerk, being able to communicate with people is it's the most basic part of our, DNA and makeup. And so being able to work with other people and to communicate what you need, what's working, what's not working, is the best way for you to evolve and for you to figure out what the game plan is. And so a lot of my cases, I end up having multiple parties on them. There'll be like complex construction issues where there's 3 or 4 parties, subcontractors, contractors, vendors, association, unit owner, all kinds of people involved. And when that happens, you need to be able to have at least a rapport with your other counsel. Otherwise, you're just going to be fighting all the time. So even if they're not someone you're working with on the same side, you might have alignment on some of the issues that you can kind of knock those things out. And so then you never know when you're going to see that person on the other side, or if they are going to be on the same side. And so it's much easier if you can figure out a way to get along with people and help each other, because ultimately, sometimes you can't. Your clients have their positions, and sometimes that can't be helped. But in the situations, it can still continue to be civil and respectful and professional and courteous to everybody.
That's great. Certainly advice to live by. Let's talk about another summary judgment that you had, and I believe this was there was a policy that was voided essentially because of a misrepresentation on the application. Can you please take us into that matter and some of the key sort of work that you did there and some of the key takeaways for you from that?
Sure. And boy, do I remember that one for a long time. That it was a very interesting issue because of the way policy language was worded. It started creating a big change in, there's always been that dynamic and difference where, people look at the insurance company, big bad insurance company, or, insurance company that's helping paid for and, resolved any of the issues that you may have had, whether it be, a homeowner's claim, a business claim, anything like that. The big thing was looking at the language and the policies and the intent, and being able to navigate the differences in some of the language goes into basically a rabbit hole that I like to go into because I love details, and I can just get lost in it. I try not to, but I can get lost there. And it was just important to start seeing some of the cases were coming out in that way, where it doesn't matter whether or not, in that case, for example, that it doesn't matter whether you intentionally misrepresented it or not. If you made a misstatement, it's material to the insurance that would have been presented. And in that case, the homeowner had multiple prior water losses that they wouldn't have been qualified for their policy. So had those been listed, the policy would have never been written. And so a lot of it goes into the difference of, I deal with a lot of cases that are fraud and bad faith and those issues where the difference is, was there a concealment or an intentional misrepresentation, whereas the difference of there not needing to be an intent requirement on it, it's going to the fact that it would be unfair to the carrier, because had they known about this, they would have never issued the policy. And so it's a balancing there. And that was a very interesting issue that I got to work on. And, we got a favorable result on that case. But it was a lot of, again, research and spending the time to gather all the information that we needed to support it. And it was a great case in just regard where you really were looking at the issues presented. And it wasn't so much about, this witness said X and, the document says Y. It wasn't that. It was literally more so based on a fairness aspect, which to me is an important part of, when you're dealing with a case of what is right, what is just, and what is fair. And sometimes you don't always get the fair, but at least a recognition that there are some issues that need to be addressed in that regard with down the road, a lot of the reforms that we've had in some of the policy language that we see coming out after these kinds of issues arise.
Got it. Thank you for sharing that. That sounds like an interesting matter to have gone through. So thank you for sharing your experience there. Switching gears a little bit, Melissa, to technology. And so you've written an article on tips and tricks for the online deposition. And so, you're a people person. I would assume you like being in the room with all the various parties. But what is your take on online depositions and how effective or not they are, when you need to read a witness in sort of the types of matters that you handled? And what are some of the ways in which an attorney can sort of make the most of that situation?
Right. And so that's one of the things that kind of traverses a bunch of the different areas that after the pandemic, during and after the pandemic, it became a completely different landscape of how one practices law in any area that you're in, especially even now with AI is a completely different aspect of it. But in terms of when we had to go into remote for everything, no one was prepared or equipped to do it. And so when I had written that article, that was just kind of from firsthand experience, figuring out right away, because I didn't have much option. I didn't have very much time, that I was figuring out on the computer, okay, how can I use this? What's the most efficient way to share my screen, get information? You have issues with remote desktops. You can't get into things. So really it was more of something that I saw as a necessity in that time, because I was a younger attorney. There's a lot of people who have been practicing for a long time who rarely use their computer, and most of the things were typed up by their paralegal or their legal assistant or whoever the associate was. And the only thing they used the computer for was to check email. And so it's something everyone had to adopt to. And the goal with that was to figure out a way that you can stay organized and still collect all the information that you need, because what you want to make sure is you don't have somebody that's taking the deposition on a phone, driving in a car, can't see the document you're sharing. You want to make sure that you have all your documents ready to go, because you can't physically hand it to the person and go line by line through it. So you have to figure out what's the way you can highlight this on a screen and make them follow with you. So a lot of that was just geared towards figuring out how do we still get information the same way and at the same rate that we would. And it requires, changing your expectation on some things, but also being cognizant and knowing and preparing ahead of time, where you'd always be, preparing all your documents, but you'd just be getting all that ready, throwing it in the car and driving to wherever your deposition is. Now you have to take an extra step, and you need to get everything saved, downloaded onto the computer in a place that you can access it, so that if something crashes, you can still use your screen, you can still present the information and not get, flustered or bogged down in it. And so one of the things I think that's the most important thing is really just being prepared in these instances, because it's a lot harder to operate on the fly if your technology is not cooperating with you. It's a whole added element that you don't need on top of, you forgot to print, the item, or you left it on the copier. That's an easier fix than, you don't have access to any of your files or information, and you're in a deposition and you don't really have a good grounds or reason to change, move it, or postpone it. You need to be prepared for those types of situations, especially if you're under a trial order.
Makes a lot of sense. Melissa, you mentioned AI a couple of minutes ago, and I want to bring that into this conversation in the context of some of the work that you do around insurance fraud, SIU, special investigative unit type work. And so as some of those claims become more sophisticated in terms of the matters that you're seeing, what role does AI play in sort of in the claims that are brought forward, as well as in terms of how you can use AI to sort of work through these matters?
And that's something that's evolving right now. And I'll be very frank with you. I don't like the use of it in law. It's something that is a necessary part, and I'm embracing it and want to learn as much as I can about it, because I know that we're going to need to use it. And the thing that's I'm most cautious about, and I'm at the same time very excited about, is we're actually doing a pilot program right now where some of the attorneys in the firm, and I'm one of those attorneys right now, to test out a program and see how it helps us to digest and distill information quickly and efficiently to give our client. But the big thing that people need to be concerned and cognizant of if they're starting to use AI is there's two different types of AI. And so the AI you're seeing in ChatGPT is generative AI, where that's where it's making things up, because it's just pulling from scenarios and giving you what you want to know, even if that's not the correct answer. And that's where a lot of attorneys are getting in trouble. There's even been a recent opinion out of our jurisdiction here in the 11th Circuit for Miami, there's a requirement that you must put a certification on your pleading saying that this document was created with the assistance of AI and all the information and citations in here are true and accurate, because the courts don't need to be looking and seeing that the person cited to a make-believe case that doesn't actually exist. And so many attorneys have gotten in trouble. They've started sanctioning attorneys. They've been doing bar complaints. It's not an area you want to be in if you're not using it responsibly. And that's where the other form of AI, and I always forget what the actual term is, but instead of it being generative AI, it is basically limited to what information is being fed to it. So it can't pull information that's outside of the software it's in. So if you're downloading, for example, a claim file and you want to find specific information in it, it can only tell you what's in that file. Or if you're researching within a pool of cases that someone has put into this program, it's only going to pull those real true cases. And that's where it can be extremely useful and beneficial. On one case where we've had, I can't tell you the number of documents that have been exchanged. It's got to be probably in the hundred thousands of pages. And we were able to use one of the AI components of a, digital discovery platform that allowed us to distill and pull whatever records reference this witness, this person, this building, this piece, whatever we needed to find out, that we could pull it quickly, because it'd be impossible to look through with 6 or 7 parties in a litigation, each with thousands of pages of documents, and then with a bunch of other entities that you're requesting records from. It would just take an army and countless hours for an associate to go through and sort through that, where we used to have our discovery attorneys who just would be doing doc review. But this puts it in, the cases are moving too fast with all these new requirements, especially here in Florida, that continuances aren't being granted absent exceptional circumstances. The orders are being given for people to turn cases, both on the state and federal level. You don't have time to do that and find that information quickly. And so these are excellent tools that, the more you're familiar with them and know how to use them, that it can help make your practice much more efficient, and is something that we all need to learn, because it's going to be a part of the practice. You can't continue to ignore it. It's here.
Yeah, absolutely. Yeah, it's all sort of a little bit of the Wild West in terms of where things are going to go with regards to these tools and these platforms and attorneys' use of them. Thank you for sharing that, Melissa, your perspective on that. This has been a great conversation. I want to take it now sort of back to where we started with your connection to Miami and the University of Miami, and then the Miami community in general. So you are now the president of the Miami-Dade Bar Association, and from what I understand, younger lawyers are busy. They have all sorts of things going on at the firm, so on and so forth. What would your motivation be, or what would your sort of pitch be to a younger attorney who may be like, hey, you know what, I'm really busy with all the stuff in my firm, but I think I want to attend a bar association event or play a greater role? What is your message to somebody like that?
So one, it would be, like Nike says, just do it. You should do it. But the thing to me that's so important about it, especially for a young lawyer, is most of our attorneys, if anybody who's graduated in the past 6 years, they haven't, for the most part, likely been in a courtroom. They haven't gone to a motion calendar practice. They haven't practiced in the world that we were in before COVID, where you'd go to a motion calendar, there'd be 100 attorneys, and you'd see 3 other attorneys that you have on other cases, and you could work out your issues there. And that social aspect was forced in those environments. So you had that personal connection with people. And now you don't have a personal connection with anyone unless you go out and get it. And the problem I'm seeing that a lot of people, as new attorneys coming in, they don't see the value in it because they don't have to. They can stay home. They can stay on their computer. Why would I go out? Why would I spend more time, have to go back, bill my hours and do that? And it's because, in the long run, again, it comes down to the relationships and the people that you know. And that's the most important part of the practice is building those relationships, because you never know when you're going to need that advice or that person's help. And or that mentorship. And that's how everyone makes those career changes and ends up, either starting their own firm or running for judge, running for state office. All of those things come from those relationships. And so for me, being a part of the Miami-Dade Bar has always been important to me because it's our largest voluntary bar association in Florida. And it's one, a tremendous networking opportunity. Two, there's just the value of a lot of the events and information that you can get from going to those events. And number three is giving back and being a part of the legal community. I owe a lot of the opportunities I've had, as I've said, to some of my law grads and friends, and as well as the people that I've met and networked, even starting in law school at events that were thrown by the Miami-Dade Bar and other affiliate bar associations. And so being present in your community is just a great way for you to open so many other doors that you may not have thought were there. And that's where I've made so many friendships and connections and mentorship that I've had along the way, and or I've been able to provide to newer attorneys. As just an example, I was at an event on Wednesday night. I ran into a girl who had been one of our law clerks when I was a young associate. She's now just opened her own firm and was asking me how and what the benefit of, getting involved with the bar would be now. And I was explaining, it's a great leadership opportunity. It gets you out in the community, what's happening. You can meet some really great people, great source of referrals. There's so many ways that you can benefit from it that it's just, what do you have to lose? And the answer is nothing, but you have everything to gain. And so it's, to me, important to, keep our professionalism, our relationships with our judges, our other practitioners, our legal support vendors, that we are a community, and the more we work together, the better we can make it.
That's amazing. Yeah, it really does speak to your very high level of involvement in the Miami community, and I'm sure the community appreciates that as well. So thank you for sharing that. So going back to your school, your law school and your college. So you moderated a panel, I understand, called "Women of the U Fail Forward." And that seems like a sort of a provocative kind of title, but if you could go back to your first year as an associate, what quote unquote failure would you tell yourself to not fear so much, because it would ultimately perhaps make you a better lawyer?
So that was a big struggle that I actually had during my first year. And it was that it was like, I'm not really supposed to be here. I was a very young attorney. I was dealing with all of these older, well-seasoned attorneys, and they're upset because they're, having to deal with little old me. That's, not what they were expecting. They wanted the other, managing or senior partner to be on the case with them. And that was a big struggle that I didn't let faze me too much, but was a true growing point of feeling like I was failing, because, there's a lot of times where, when you're a young attorney, someone's going to bully you. And especially as a young female attorney, but it really applies to anyone. When you're a younger attorney, they're going to just try and make you think and doubt yourself because you don't know. But your gut of guts is going to tell you, I know I'm right, and to keep pushing that. But I did have cases where I had, one of my first depositions I was doing, had an attorney arguing with me, giving all kinds of speaking objections, coaching his witness. I kept putting on the record, these are not appropriate. Please don't do this. We ended up having to go to a whole sanction hearing. We won that sanction hearing, but a lot of that was taking the time that in that moment I was freaking out, but I would take the break, call my supervising attorney, ask him for his advice and what to do, go back and do that. And then also, taking the moment of having the step back. When we were doing that sanction hearing, for example, I said, I'm not going to go argue that motion to the judge. It's just going to sound like I'm whining and crying because this guy was bullying me. And that's not the point. I want someone to know this was not appropriate procedure. And I'll never forget it because the judge was like counsel to the other attorney, and who admittedly just said, I was having a really bad day. I do apologize. And he was realizing that, his conduct wasn't proper. But the judge had said, counsel, you may not like how someone asks a question, but is it ever appropriate to tell someone that their question is stupid? And that was just something like I'll never forget it, just because it was in my first year. It was learning all of that information and having the confidence to still keep going. And while I wanted to like go crawl into a hole and hide, is, keeping moving with that, and trying to figure out how do you move past that, and what you need to do. And there I was very grateful. Again, is what I'm saying, to who you're learning from, is that I had someone who was there, who was helpful, and went and argued that hearing for me. And I sat there as just basically the witness for it, and someone who was supporting the argument that I had there. And that was, one of my mentors and my boss at that time. So a lot of it is that, and also just stepping into and knowing when you need to take that position argument. Like, I had a legal assistant when I started. She was much older than me, and she's going like, "Oh, can I get you coffee, whatever?" And I'm like, "Oh, no, you sit down. I should be getting you coffee," because, like, you respect the people who are more experienced and seasoned than you. But it's also knowing that role, and that I was in the attorney role. And unfortunately, I had a day where a judge called me because I missed a hearing that wasn't in my calendar, because my assistant didn't do it. And that was one of the hardest days for me too. Was, you get very friendly with people, but at the same time, there has to be that moment where you actually are that supervisor, and you are that person, and saying, this isn't acceptable. What happened? How did this happen? I can't have a judge calling me and saying, "Miss Jordan, why weren't you in my hearing? It was your motion. I denied your motion because you weren't here." And that's the worst call that you can get, because it's your license, it's your profession, it's your reputation, and those are the things that you have to make sure that you and your staff are working together, and have a system set up in place to prevent issues like that. Every once in a while something like that falls through the cracks, but that's something that was an extremely hard part in the first years of practicing, that you have to step into your role, and know you need to be cognizant, concerned, and always worried about your reputation, your license, and knowing how important that is.
That's great, Melissa. This has been an inspiring and illuminating conversation for me, and certainly for all our listeners as well, I'm sure. Final question for you: is there a question that I should have asked you but I didn't?
Oh, so that's so funny that you asked me that, because I always ask that at the end of a deposition. I always say, "Is there anything that we haven't talked about that we should have discussed? Is there anything that I haven't asked you that I should have asked you?" And I don't think that, well, I guess the only question would be just if there was, and this is the thing I always like to do and give as an advice to someone who is a younger lawyer, and that would just be advice to a younger lawyer in the beginning of their career. That would be the only question.
Sure. Yeah. What advice would you like? Because in your case, at the beginning you shared so many nuggets, but if in terms of things that you did, in terms of work that you did above and beyond, that got you on that accelerated path to where you are today. But yeah, I would love for you to sort of synthesize that and share that as advice for a young lawyer.
And so that's where, like, to me, I really enjoy the opportunity to give back and mentor and help our younger students and aspiring attorneys or in their first years of practice. But the big thing is just really don't be afraid. That's the whole thing. And it's embracing opportunities, learning from people. And so my biggest thing that I always recommend is, to that point about networking and being out in the community is, I always say, if you met at least one new person at that event, you did your job for the day. That's all you have to do. It's meeting one new person, because you never know when meeting that one person can make a difference. And you have no idea the stories that could be a whole nother day of just what that one person can make an entire difference in your legal career, your personal life, anything. And so that's where I just, I really encourage younger attorneys, students, or anything to, just get out there and go meet people. And, it's scary and it's frightening, but if you make yourself talk to at least one new person, I think that it will pay off in the future.
Thank you. Well, on that note, Melissa, thank you so much for your time, for your insights, and for sharing all of these stories with us. I certainly enjoyed the conversation. I'm sure our listeners will as well. So thank you very much.
No, thank you very much, Aniket, for having me here. It's been wonderful to talk with you, and I appreciate all that you're doing to try and share knowledge with everyone. And I think it's wonderful what you're doing here with this podcast. So thank you again for having me.
I appreciate the kind words. Thanks.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.